Hello and welcome to this podcast on the English and Welsh legal system with Ryan Murphy. Today we are going to be looking at the features of reported case law. And so any study of the law and legal system of England and Wales will result in you having to locate, analyse, digest, comment upon, use and apply case law. This is because the legal system of England and Wales is one of common law, where judge-made law is particularly important. And this judge-made law gains its authority from the judgments of the courts, and you can find those judgments reported in case reports. And what I would like to do is just introduce you to some of the common features of case law, and particularly of a reported judgment, and to get you to start to think about how you can use that to make your exploration of the case law more efficient. So let's make a start. You can see on the screen now a list of the main features of a case, a reported case, and it might be sensible for you to pause the recording at this point to consider and to digest what those features mean. You'll see that there are some that appear in what we call the neutral case report, the neutral case citation, and that's the official judgment handed down and published on various court websites. So we'll look in particular in this podcast at a case that's been reported and issued on the website of the Supreme Court. And also, in addition to that, there are a number of commercial law reports. So this is commercial and non-profit organisations who publish certain judgments. They report judgments, and they all have their own criteria for which cases they report and which they don't. Some are very specialist journals that report on specific areas of law, and some are more generalist in their outlook. And there are some minor differences between the case report based on the neutral cited case and those that you will find in the published law reports. So without further ado, let's take a look at a case. So the first thing that you'll notice, and this is something that is peculiar largely to the Supreme Court, is that it will tell you which term of the legal year that the case is decided in. So there are 4 terms. There's Hilary, there's Easter, there's Trinity, and there's Michaelmas. And they make up collectively the legal year, and the legal year is always kicked off with a ceremony at Westminster Abbey where judges, QCs and others involved in the legal system gather upon Westminster Abbey, and it's a ceremonial thing which dates back to the time where judges would pray for guidance at the start of the opening of the legal year. So we'll see that this was decided in the Hilary term. That's, as I say, just a bit of historical consequence largely. Then you have what we call the neutral citation. And so the neutral citation is a way of reporting cases, giving each case a unique identifier that will help you to find that you're looking for the right case. And these citations will be brought forward to in future cases as well. If you wanted to rely upon the arguments within a case, then you would have to give its full citation. So here we can see that this case, the square brackets tell, the number within the square brackets tells you the year. So this was decided in this case, which was decided in 2020. You can see that next to that, it has the identifier UKSC. So this tells you that this case was decided in the UK Supreme Court, UK United Kingdom, SC Supreme Court. If it had, for example, as we'll come on to see where it's appealed from, there are other court identifiers. And then the final number, the number 12 at the end, tells you that this was the 12th case decided or judgment handed down of 2020. So this is the 12th case in the UK Supreme Court in 2020. So that is a really, really useful piece of information. It can help you to locate the case in the first place and to check that you're looking at the correct case if there are multiple cases with similar names or cases between the same parties that have happened in different years. Then you can see that there's some appeal information, so you can tell some of the procedural history of this case. We know that this case, as a result of the information on the screen, was decided in 2018. The EWCA space Civ tells us that this was decided in the Court of Appeal Civil Division, CA Court of Appeal, Civ Civil Division, and that we know that this is the Court of Appeal of England and Wales. So EWCA, the Court of Appeal of England and Wales, its civil division. And you will see that this case was decided in 2018 in that court, and it was the 2,339th case to be decided. So if you wanted to, you could use that appeal information to find the case that's being appealed and to read in more detail the judgments that have led to this appeal to the Supreme Court. So in some ways, that information will be right at the forefront of the judgment, and it'll be easy for you to find and to locate. And it's a way of sort of tracing case or of finding case or of exercising your research skills. So if we then look at other features, you will see that the parties are listed on the screen. So those who are appealing against the judgment of the Court of Appeal of England and Wales, they'll be first. And then you will have the respondents, those who are responding to the appeal. Okay? So we can see that this is a case involving Morrison's Supermarket, and it's appealing against the judgment, as I say, of the Court of Appeal of England and Wales. And then what you can see once you move below the parties is you can see the judges. So it will list, you can see that there were 5 judges on this case: Lady Hale, Lord Reed, Lord Kerr, Lord Hodge, and Lord Lloyd-Jones. If, for example, people have different roles within the justice system, then they will be denoted by that title at this early stage in the case. So you'll be able to see that these are all Supreme Court justices, so they all have essentially the same title, other than Lady Hale, who is, by virtue of being a woman, gets the title Lady, and the others are men, and by virtue of that get the title Lord. But you might see things like Mr. Justice. You might, at lower down the court hierarchy, you might see Lord Justice. You might see, if someone is Master of the Rolls, that would be indicated if someone was the Chancellor of the High Court. You can see that the judges and their judicial title will appear. So you can see who decided the case and what their position in the legal order is. In the Supreme Court, it will inevitably be Supreme Court justices, but as you move down through the ranks, through the hierarchy of the courts, different judges sit in different courts. And so you might have more of a mix of titles and of seniority of judge sitting on a particular case. So as I say, most importantly, you have the parties, but you can also see the judges who decided the case. And as you become more familiar with the legal system of England and Wales, you will find that some of these judges have fairly strong personalities, that they have different specialisms, that they have different variances in how much they contribute following a lead judgment. And you can see right from the start whether your favourite or your least favourite judge is hearing a particular case or heard a particular case. Moving then, the other thing that you can see is you can see the counsel. So you can see who appeared for the appellant in the case and who appeared for the respondents. So here we can see that there were some QCs in this case, so Queen's Counsel, so those barristers who are the most senior of barristers who've taken silk. You have Lord Panic appearing for the appellants, and then if you go over to the other side, you can see the counsel for the respondents, including like Jonathan Barnes. So this can be really, really useful if you want to know who appeared in a particular case. And you will see the instructing solicitors are also listed. And so one of the things that you might do as you explore potential for work experience is you might have a scan through recent judgments and find out whether the firm to which you're applying appeared in a particular case or instructed barristers in a particular case. And you could weave that into your narrative as to why you would like to have some work experience with the firm. You're interested in that sort of work, for example. So that's the counsel in the case. Then you have some other important information. You will have the date of the judgment. So here it's the 1st of April 2020, so a recent case. You can, as I say, you can find out when the judgment was given. You can also find out when the hearing dates were. So you can see that, that partly because of the Christmas break, but that there was a gap between when the case was heard over 2 days in 2019 and when the judgment was given. And what's really important is that to note is that cases are reported by the date of judgment, not by the date that they were heard. So that's why the indicator at the start, the neutral citation at the start, contains 2020 date, because that's when the judgment was actually given. What you can do with this information is you can go to, say, the Supreme Court's website, which is a very, very good website. You can go back, you can, if you wanted to hear, because they're recorded in the Supreme Court, unless there are reporting restrictions, you can hear the arguments of counsel. And so if you're interested in advocacy, for example, if you are interested perhaps in becoming a barrister or sharpening your advocacy skills, one thing that you can do after reading a judgment is to think, well, what helped the judges to come to the conclusion they did? Were they persuaded by the strength of the advocacy, by the strength of the legal argument put forward by the barrister in the case? And what you can do is you can go back and you can look at different styles of advocacy. So one of the good reasons of having the counsel listed on the report is that if you are thinking, I wonder how Lord Panic QC presents the case, you can go back, you can go in, you can actually watch him present his argument. And that can be really fascinating, because I think sometimes there is a perception that advocates are a model of perfection. If you appear before the Supreme Court, then it must be that you never stutter over your words, or you never lose your place when directing a judge in a bundle. And if you just watch some advocacy in the Supreme Court, you will see that whilst they are very, very good and very strong and all the rest of it, they also make mistakes. It can be quite heartening to watch a professional at work and to see how they present a particular case. Then what you will have, particularly in appeal cases where you have multiple judges, or you're much more likely to have multiple judges, and in the Supreme Court you can see here that, that there were 5 justices in particular. Each justice has the opportunity to speak as part of the judgment, to give their view in the judgment. Here what we'll see is Lord Reid gave the leading judgment. So Lord Reid wrote the initial judgment, and you can see here that the other 4 Supreme Court justices agreed with him. Now, one of the wonderful features of the English legal system is that judges don't always agree. And so for that reason, you will often have, particularly on appeals, and the more important appeals, the more you'll have, an odd number of judges sat on a case, so that a case can always be decided. You never end up in a situation where you have a dead heat between 2 camps of judges. And unlike something like, say, the European Union, where their court comes to one collegiate judgment, you don't know who disagrees with who and on what points, the English legal system allows for that disagreement to exist. Here it doesn't. So in this Morrison's case, all of the justices were agreed. But if they hadn't all agreed, then you would have, as well as the leading judgments, you would have things like dissenting judgments. So judges who would have settled things differently, and they will give an analysis of why they've come to a different outcome to their fellow Supreme Court justices. You might have majority and minority judgments where essentially the outcome is the same or largely the same, but the reasoning is slightly different. And that's one of the jewels in the crown of the legal system of England and Wales, is this ability for judges to disagree and to have their own say. And what might happen in the future, it happened to Lord Denning a couple of times, more than a couple of times, is that your dissent in one case might actually become the law later. So people might refer back to your dissent and say, okay, you were not in the majority then, You were not in with the other judges on that occasion, but actually we're really persuaded by your reasoning, and now we're in a situation to adopt that dissent as the law. And that can sometimes happen, not always, but it can sometimes happen. And so it's useful for you to know that you have this lead judgment, and potentially you have each of the other judges capable of saying something else. Sometimes they just say, I agree. Sometimes they say, I agree, but my reasoning is slightly different. And sometimes they say, I disagree with the lead judgment. So that's the concept of the lead judgment, that it also contains a summary of, or it can contain, and this is judicial preferences come into this a little bit, it can contain a useful summary of the case. So always read the opening paragraphs of the lead judgment, because it will tell you what this is about. So it tells you this appeal is primarily concerned with the circumstances in which an employer is vicariously liable for the conduct of its employees. And essentially, that's what this case was about, a matter of employment law and understanding this concept of vicarious liability for the conduct of employees. So if your employee does something within the course of their employment and injures someone, causes some harm, fails in a legal obligation, to what extent is the employer responsible for the actions of its employees? That's essentially what this case was about, and the release of data, personal data, that was in breach of the Data Protection Act. So then what you can often get in the leading judgment is the facts of the case. So the person handing down the leading judgment, giving the leading judgment, half the court, will often summarize the facts, and they will often be quite explicit about that and say, these are the facts. And that can be quite useful to sort of just do a Control F so you can find where the facts are. Then often, when you get to appeal judgments, you will get some form of procedural history. The judges will label this differently, but you will find out what has led to the appeal. So you'll have the basic material facts of the case, to the facts that led to the legal issue in the first place. And then you will often get the appeal court judges dealing with summarizing the position of the court below, of the court from which this appeal has come. And so that's that. And then the bulk of the leading judgment will be formed of legal analysis. And this will be, judges might split it into different, if there are different arguments, if there are different legal threads, if there's a different way of looking at legal issues, they will or normally split it down into those constituent parts. So here we can tell that Lord Reed's first piece of legal analysis is whether Morrisons is vicariously liable for Skelton's conduct. So in essence, is the employer Morrisons liable for actions taken by Skelton in publishing personal data without their permission? And different courts, different judges have different practices of how they label this, but the bulk of the judgment will be this sort of legal analysis. Based on the material facts, what are the legal issues? How do those legal issues relate to the appeal, to the case which is being appealed? And then what is the legal position? And then right at the end, some judges call this conclusion, others in lower courts sometimes call it the disposition. What is the fundamental conclusion of the courts? They do their legal analysis, they tell you what the legal analysis is, they apply that legal analysis to the facts, and then they come to a conclusion. So here the conclusion in paragraph 56 was, for the reasons explained above, the circumstances in which Skelton committed wrongs against the claimants were not such as to result in the imposition of vicarious liability on his employer. Morrisons cannot therefore be held liable for Skelton's conduct. It follows that the appeal must be allowed. Remembering that Morrisons were the appellant. They were appealing against the decision below, which was that they were liable. So you can tell quite a lot just in the language that's used here. You can tell that the employer in these circumstances was not responsible for the actions vicariously of its employee. And we can tell that the appeal was against a finding of liability earlier, and that Morrisons is not liable for Skelton's conduct. So that's a very brief summary of the legal features, the features of a reported case. If we then think that was based on the neutrally cited judgment given on the Supreme Court's website, so you could go away and find that if you so wish. But now, what I want to do is to draw your attention to some features that are present in other forms of law reports, but A, do not form the basis of the judgment, and B, can be both helpful and dangerous to those studying law. So if you go to one of the official series of law reports that are published, and you can do that with multiple different publishers, those who publish these law reports, but they are not the judgment itself. They are reports of the judgment. They'll contain the judgment, and they will contain essentially a copy over of the stuff that appears on the neutrally cited case report. But there are some additional features that can be both helpful and unhelpful. So most reported series of law reports will have some key words at the top of the judgment. So this aids you in your search. Is this case something that's relevant to me? Rather than starting to read Lord Reed's leading judgment before figuring out whether this is about supermarkets and supply chains, whether this is about supermarkets and food safety, or whether in this case, this was about employers and vicarious liability. So those words would appear as key words at the top of the law report. And that can be really helpful to you as you search for, as you investigate case law. That there will be something called a head note, and this is something that lots of students really, really like. So the head note will contain a very, very brief summary of the facts, it will contain a very brief summary of the judgment, and it will normally contain a list of cases that have been cited in the judgment. And so in essence, it allows you to have a very brief snapshot of the case. As I said, this is not an official part of the judgment. This is something that the reporter who works for the law report thinks is important, or thinks that would be useful to those in legal practice or in legal study. And so these head notes are things that students often rely upon when preparing for their coursework. Now, that's fine. It's a helpful way of digesting very complex judgments, but nothing beats, nothing replaces reading the judgment in full. And always remember that the head notes produced by the law reporters are not the judgment itself. They are a summary of the judgment, and so don't copy from them. Use them as a way of guiding your reading of the full judgment. So there are a couple of activities before we say goodbye. And the first of those is to go and find a case. So go to the Supreme Court's website, which is listed on the screen now. Using the search function, if you search for the Radmacher case, then what you can see is a really important case in family law. And using the labels described in the rest of this brief podcast, can you identify the key features of the case? So I broke down the case for you, I took it apart, I only give you a snapshot of bits of it. Could you use the labels I've given you to go away and analyze that case? Now, you won't have studied, or it's unlikely you'll have studied family law and the law relating to pre and post nups and all that sort of stuff. But it would be really good for you, I think, to read a case in an area that you don't understand, that you don't have familiarity with yet, to see if you can at least unpick the case. And then the second thing I'd like you to do is to navigate to the judgments page of the Courts and Tribunals website. So the link is given on the screen again. And what I would like you to do is, using a different method, so rather than using search terms as the names of the party, use a different method to try to find this case. So this is the 921st judgment of 2020 in the High Court. So go to the judiciary.uk/judgments website and see if you can find that case. This is not an appeals case, so this is what we would call a first instance case. And what I would like you to do is to, again, try to use the labels that I've given you to identify the features of the case. You will see that some of the features I've given you, some of the labels, don't quite work in this, the 921st judgment of 2020 in the High Court. Reflect on why that might be the case. And so what I hope this podcast has done is to introduce you to the features of case, get you thinking about those features, get you thinking about how you might use those features to improve your legal research skills, your legal reasoning skills, and your skills of analysis, but also think of the limits of that framework. So if you adopt an overly rigid approach to legal study, then you'll soon come undone. And what you will find is that information given to you, like labels and frameworks and all the rest of it, have their limits. And there is an awful amount of freedom in how judges and courts present their judgment. There's not a unified way in which they do it. And these labels are only supposed to get you thinking. They're not intended to be definitive or exhaustive. And really, that's all I wanted to talk to you about today. And so I hope that you found it useful and interesting. And I hope that you will be back again looking for more podcasts on the English and Welsh legal system. Thank you so much, and goodbye.